Have learned section 31, in which we have seen sale prospectus. Now we are going to learn red herring prospectus. Red herring prospectus meaning have been defined in explanation to section 32, where it says red herring means a prospectus which does not include complete particulars of quantum or price of securities. Need of red herring prospectus. Developments taking place in the financial markets from time to time allow innovative methods of raising funds so as to avail the most of favorable market condition. Timing, the issue, and book building of issue are facilitated by the concept of red herring prospectus, whereby the price per security and number of securities are left open to be decided post closure of the issue. Here, the concept of book building, which we need to understand, it is actually a price discovery method. In this method, the company doesn't fix a particular price for shares, but instead gives a price range. And underwriter builds a book by accepting orders from fund managers and indicating the number of shares they desire and the price they are willing to pay. The section 1 of subsection 1 of section 32, the of red herring prospectus deal with the timing of issue of red herring prospectus. A company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of the prospectus. Filing of red herring prospectus with registrar, which is which is mentioned in subsection 2 of section 32. A company proposing to issue a red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. Obligations under red herring prospectus vis-a-vis prospectus, which is mentioned in subsection 3 of section 32, that a red herring prospectus shall carry the same obligation as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variations in the prospectus. Filing with registrar and SEBI upon closing of offer. Subsection 4 of section 32 says that upon the closing of the offer of securities under this section, the prospectus stating therein net total capital raised, whether by way of debt or share capital, and the closing price of the securities and any others details as are not included in the red herring prospectus shall be filed with registrar and Securities and Exchange Board. Then we will see the concept of a bridge prospectus. Issue of application forms for securities, section 33. Meaning of a bridge prospectus has been defined in section 2, clause 1. A bridge prospectus means a memorandum containing such salient features or prospectus as may be specified by SEBI by making regulations in this behalf. Need of a bridge prospectus. In fact, a bridge prospectus is a summarized form of actual prospectus containing the salient features of prospectus to cut the cost involved in the publication of large number of prospectus, which has to accompany the application form for shares or debentures in case of public offer. A bridge prospectus accompanied the application form, subsection 1. Section 33, subsection 1 provides that every application form for shares or debentures has to be accompanied with the abridged prospectus. Proviso to subsection 1 provides exceptions when the requirement of abridged prospectus does not apply. When application form is issued in connection with bona fide invitation to a person to enter into an underwriting agreement with respect to shares or debentures, and in relation to shares or debentures which were not offered to the public, and the offer is made only to the existing members of the company. Right to receive prospectus. Subsection 2 of section 33 says that provides that full prospectus is to be made available to any person who requests for it before the closing of the subscription list and the offer. Penalty. Subsection 3 of section 33 says that a company who makes any default in complying with the provisions of section 33 shall be liable to penalty of 50,000 rupees for each default. Then misstatement in prospectus. Now we will see the misstatements in prospectus. A contract of shares in a company is a contract of Ubermai's fights, which means utmost good faith. Utmost good faith. The legal doctrine of Ubermai's fights provides that All parties to contract must deal in a good faith, making a full declaration of all material facts. The intending purchasers of shares are entitled to true and correct disclosures of all the facts in the prospectus. Hence, a prospectus must make all the statements with a scrupulous accuracy and not state the facts which are not strictly correct. Neither any information which the law requires to be disclosed to the public be concealed or omitted to be stated from the prospectus, and nor should the information given or be false or misleading. Misstatements in prospectus is a serious offense which attracts the provisions of Section 34 criminal liability and Section 35 civil liability of the Act. In this section, we will learn about misleading prospectus, remedies for misrepresentations in the prospectus. What construe as a misstatement and misleading prospectus? A prospectus is said to be misleading if it includes any misstatement. In common parlance, misstatements is the act of stating anything that is false or not accurate. A statement become false statement if it produces a wrong impression of actual facts. It could either be due to a commission or omission or both. As per Section 34, a statement included in a prospectus shall deem to be untrue if the statement is misleading in the form or context in which it is included, or where any inclusion or omission of any matter is likely to mislead. Some of the landmark judicial pronouncements, only for reference and better understanding. First one is mislead through false statement, prima facie of fact. Henderson versus Lacan. It was stated in the prospectus the directors and their friends have subscribed the large portion of the capital and they now offer to the public the remaining shares. Whereas in actually each of the director had subscribed only 10 shares. It was held that such a statement is misleading one, misled by hiding truth through superficial statement, Rex versus Kilsant. In the prospectus, it is stated that the company had regularly paid dividends. In actual, company has been incurring substantial losses during all those years. Company used to write back some of the past provisions to the credit of the profit and loss account. It was held that the prospectus did not disclose the true picture of the company, misled through ambiguous statement Smith versus Chadwick. The prospectus of a manufacturing company contained the present value of turnover 1 million sterling per annum. The statement was true only if the production capacity is considered, but untrue if it means the present production level capacity in utilization. It was held that such a statement, which director knew, may bear multiple meaning, out of which any can be false to their knowledge, considered to be furnishing of misleading statement. Effect of misleading prospectus, remedies of mispresentation. The fear of heavy liability and criminal sanctions have controlled the director's tendency of using extravagant terms and flattering descriptions. But if the prospectus contains some misleading or false statement or omits to disclose a material fact which amounts to the misrepresentation, the aggrieved shareholder has the remedies. The law allows the following remedies for misrepresentation. Remedies for misrepresentation in prospectus against the company and others, and a person against the person authorized to issue prospectus. Against the person authorized to issue prospectus, one is criminal liability and damages for deceit. Against the company and others, civil liability for compensation, and against the company, rescission and damages. Now we will see the remedy of rescission, damages and deceits. Damages and deceit are not specified under this Act. They are available under Indian Contract Act 1872, read with relevant provisions of the Specified Relief Act 1963, whereas criminal and civil liability is provided under Section 34. Criminal and civil liability is provided under Section 33, 34 and 35 respectively of this Act. Since remedies specified above are alternative courses, hence all of these remedies are not available simultaneously, whereas the appropriate combination of these can be claimed. To illustrate, claim for compensation under Section 35 civil liability of this Act being special statute where jurisdiction power is vested in SLT shall not be moved simultaneously with the claim for damages under general provisions. Right of rescission. When to seek rescission? A person who has purchased shares from the company on the basis of the prospectus containing untrue and misleading statement of material facts is entitled to apply to the court for the rescission of the contract under the relevant provisions of the Indian Contract Act 1872. Effects of rescission. The agreement to take up shares is voidable at the option of the subscriber to the shares. It will remain valid unless he actually resigns it. If the court accepts his application for the repudiation of the contract, then company will remove his name from the register of members and return his money with interest and other incidental costs. Entitlement to compensation for any damages which he sustained through the non-fulfillment of the contract arises under Section 75 of the Indian Contract Act 1872. Exceptions when rights of rescission is not available. Right to rescind allotment of share will not be available to the subsequent purchasers of the shares from the market. And a subscriber to the Memorandum of Association cannot also seek any relief as the company cannot be considered to be in existence at the time when he appends his signature to the Memorandum of Association and he cannot